Sell it. $2,500 is more than enough for that worthless lot. Linda Crawford smiled as she signed the papers that stripped Daniel Whitfield of the small parcel of land he had owned for 11 years, after months of relentless fines and a formal declaration that he had abandoned his own property. The neighborhood laughed, certain that the quiet architect had simply lost a patch of dirt nobody wanted anyway. 7 months later, inside a courtroom, packed shoulder to shoulder, a judge set down a geological survey and spoke a sentence that silenced the entire room. This land was never worth $2,500. Its true value is $31,400,000. From that moment forward, everything in Daniel Whitfield's life began to unravel in the opposite direction Linda Crawford had planned. Daniel Whitfield was 46 years old, a retired architect who had walked away from a demanding career after a series of quiet successes allowed him to stop working, long before most men his age even considered it. He lived alone in a modest house on the edge of a gated community called Ashwood Ridge, a place of manicured lawns, matching mailboxes, and rules for everything from mailbox color to the height of a hedge. He had no wife, no children, and no interest in the social theater that consumed his neighbors. He was calm in a way that unsettled people who expected loud reactions, the kind of man who listened twice as much as he spoke and who measured his words the way he once measured blueprints, with precision and patience. Years earlier, before Ashwood Ridge had even finished its second phase of development, Daniel had purchased a small parcel of land sitting just beyond the official boundary of the community, a rocky, weed-choked strip that no builder wanted and no neighbor valued. He bought it quietly, almost as an afterthought, because something about its isolation appealed to him. The Homeowners Association of Ashwood Ridge was run by a woman named Linda Crawford, 55 years old, sharp-featured, and utterly convinced that her authority extended to every square foot within sight of the community gates. She had built her reputation on control, on committees she chaired and rules she rewrote to her liking, and for 3 years she had set her sights on expanding the community clubhouse directly onto the edge of Daniel's land. She believed, with the confidence of someone who had never been told no in a long time, that the parcel was rightfully an extension of the association's territory, regardless of what any deed might say. "That eyesore drags down every property value on this street," she told the board more than once, her voice carrying the practiced outrage of a woman who had turned complaints into a weapon. She approached Daniel directly on several occasions, offering him what she called a generous buyout, and each time he refused politely but firmly, explaining that he had no intention of selling. Refusal, to Linda Crawford, was not an answer. It was an obstacle to be removed. Within weeks of Daniel's final rejection, the letters began arriving. A citation for overgrown grass on land that technically fell outside any homeowner's obligation to maintain. A fine for a broken section of fencing that had been broken since before Daniel even purchased the property. A notice for failure to maintain drainage standards. Then another for improper signage. Then another for a violation so vague that even the language on the letter seemed designed to confuse rather than inform. Daniel paid the first 2 fines simply to avoid conflict, but as the citations multiplied, he began to sense a pattern forming beneath Linda's smiling insistence that these were routine enforcement actions. He tried more than once to reason with her directly. He sat across from her in the association office and laid out calmly that the fines she was issuing had no basis in any covenant that governed his property, since the parcel sat technically outside the community's official boundary line. Linda only smiled at him the way a teacher might smile at a slow student. "The boundary is a formality," she told him. "Everyone here treats that land as part of Ashwood Ridge, and everyone expects it to be maintained to our standards." Daniel pointed out gently that expectation was not law, and Linda's smile thinned into something sharper. "You'll find," she said, "that I don't lose these arguments. Not here." The other residents, watching the drama unfold from behind their curtains and community newsletters, began to take sides, and increasingly those sides favored Linda, the woman who baked cookies for the holiday social and organized the annual charity drive. Daniel became, in the eyes of many, the stubborn outsider clinging to a worthless patch of dirt out of pure spite. At the monthly community meeting, Linda stood before the room and described him, without ever using his name directly, as a resident who refused to be a team player, a phrase that drew nodding heads and murmured agreement from neighbors who had never once walked the land in question. What no one in Ashwood Ridge knew was that Linda Crawford had already begun holding closed-door meetings with 2 members of the Homeowners Association Board, a retired banker named Walter Griggs, and a woman named Diane Foss, who owed Linda a favor from a business dispute years earlier. In those meetings, held quietly after the official board sessions ended, Linda laid out a plan disguised as procedure. She explained that mounting fines, combined with accruing interest, could eventually be framed as evidence of abandonment, a legal maneuver that, if executed carefully, would allow the association to seize the property and auction it off under the authority of its own governing documents. Walter Griggs raised a quiet objection about legality, and Linda dismissed it with the same confidence she used on everyone who questioned her. The association's attorney, a man named Gary Mercer, who had represented Ashwood Ridge for nearly a decade, and who understood exactly which side of his bread held the butter, agreed to draft the necessary abandonment notice. That notice, required by law to be sent by certified mail to ensure Daniel received proper warning, was instead sent to an address that had not been his in over 6 years, an old post office box he had closed after moving into his current home. Whether the error was a genuine mistake or a deliberate act of sabotage, only Gary Mercer and Linda Crawford knew for certain, and neither of them cared enough to correct it. Daniel Whitfield, unaware that any notice had even been issued, continued his quiet life exactly as before, checking on the land occasionally, paying his fines when they seemed reasonable, and assuming that whatever friction existed with the association would eventually settle the way most neighborhood disputes did, through attrition and time. Instead, a private auction was quietly arranged and conducted within the association's own procedures, attended by a small handful of people who had been informed in advance. The land sold for $2,500 to a company calling itself Meridian Point Holdings, a name that meant nothing to anyone at Ashwood Ridge and that appeared, on paper, to be an unrelated real estate investment firm. No one asked deeper questions. No one thought to trace the ownership structure behind the name. What the residents of Ashwood Ridge did not know, and would not learn for many months, was that Linda Crawford held a controlling stake in Meridian Point Holdings through a chain of paperwork, designed specifically to obscure her involvement. Daniel discovered something was wrong on an otherwise unremarkable afternoon when he drove past the edge of his property and saw, planted directly in the rocky soil, a metal sign bearing 3 words that made his stomach drop. Private property, it read, along with a company name he did not recognize. He parked his car on the shoulder of the road and walked the perimeter of the land in stunned silence, running his hand along the new sign as though touching it might reveal it to be a mistake, some clerical error that could be resolved with a phone call. It was not a mistake. It was the beginning of something far larger than he understood. The following morning, Daniel walked into the Ashwood Ridge management office expecting confusion to be cleared up quickly. Instead, he found Linda Crawford seated behind her desk with the composed stillness of someone who had rehearsed this exact conversation. "You lost ownership of that property months ago," she told him, her tone carrying no trace of apology. "It went to auction. It's no longer yours." Daniel asked, calmly at first, to see the documentation, the notices, the records of the auction itself. Linda slid a thin folder across the desk, containing only a summary sheet, nothing that resembled proper legal notice or proof of certified mail. When he pressed further, asking who had purchased the land and under what authority the association believed it had the right to seize it, Linda's expression hardened into something colder. "That information is not something I'm required to share with you," she said, and within minutes, a security guard appeared at the office door to escort Daniel outside. No one in the neighborhood offered support. He mentioned the situation to a longtime neighbor, an older man named Frank Delgado who had lived at Ashwood Ridge since its earliest days, and Frank only shrugged. "It's just dead land," Frank said. "Nobody ever used it for anything. Why fight over dirt and rocks?" Daniel found no comfort in that response. No matter how many times he heard some version of it from other residents who preferred to see the dispute end quietly rather than risk drawing Linda Crawford's attention to themselves. He tried one more time to reach Linda directly, catching her outside the clubhouse on a Saturday morning as she supervised a landscaping crew. He asked her plainly who had purchased the land and what documentation existed proving proper notice had ever reached him, reminding her that under the association's own governing documents, any forced sale required certified notice sent to a homeowner's address of record, verified through a signature confirmation. Linda barely turned to look at him. "The sale was conducted according to association bylaws," she said, her attention fixed on the landscapers trimming a hedge behind her. "If you have concerns, you're welcome to raise them with legal counsel." She said it the way someone might mention the weather, indifferent and final, and then she walked away before he could respond. He realized, standing alone in his driveway that evening, that if he wanted answers, he would have to find them himself, because no one else in Ashwood Ridge intended to ask the questions on his behalf. He thought back over every interaction with Linda across the past year, every fine that arrived with suspicious timing, every meeting that ended before he could finish a sentence, and slowly, the shape of something deliberate began to form in his mind, something far more calculated than simple neighborhood politics. He began at the county records office the following week, requesting copies of every document related to the parcel, from the original deed to the most recent transfer of ownership. What he found, buried among stacks of paperwork that clerks handed him with visible disinterest, planted the first seed of real suspicion. Several documents were missing signatures that should have been present. Dates on certain filings did not align logically with the sequence of events Linda had described. A notarization stamp on one form appeared to have been applied after the document had already been filed, a detail so small that most people would have overlooked it entirely. But Daniel had spent decades reading blueprints and contracts with an architect's obsessive attention to detail, and inconsistency was something he had trained himself to notice instinctively. By the time he left the records office that afternoon, his suspicion had crystallized into a conviction. Something about this transaction was not merely unfair. It was fraudulent. He spent the following 2 evenings laying every document across his dining room table, arranging them chronologically the way he once arranged architectural drafts, searching for the moment the paper trail stopped making sense. The abandonment notice, dated 8 months earlier, listed an address he had vacated years before, an old post office box he had closed after moving into his current house, and had never once used for official correspondence since. The auction notice itself, filed only 11 days after the abandonment declaration, seemed rushed in a way that struck him as strange for a process supposedly governed by careful procedure. And the buyer, Meridian Point Holdings, appeared nowhere in any public business registry he could locate. No address, no listed officers, nothing beyond a name stamped onto a transfer form. Daniel hired an attorney the following week, a sharp, methodical woman named Rebecca Kingston, who had built her career on property disputes, and who listened to his account with the focused stillness of someone already building a case in her mind. She recommended bringing in an independent land surveyor to re-examine the parcel, not for boundary lines, which were never in dispute, but for anything unusual in the geological history of the land itself. That surveyor, a soft-spoken man named Peter Alden, spent 2 full days walking the property with instruments Daniel didn't recognize, taking soil samples and consulting old topographical maps pulled from state archives. What Alden discovered, buried in a survey report filed nearly 30 years earlier and long forgotten in a dusty section of the county archive, changed everything. The parcel sat above a mineral deposit that had been noted briefly in an exploratory geological survey, a deposit rich in lithium and rare earth elements, minerals whose value had skyrocketed in recent years, due to demand from battery manufacturers and technology companies racing to secure domestic sources. The original survey had been filed and forgotten, buried under decades of paperwork before anyone understood the true significance of what it described. Alden explained, laying maps across Daniel's kitchen table, that a major energy conglomerate had recently begun quietly acquiring mineral rights throughout the region, moving from parcel to parcel with the kind of discretion that suggested they already knew exactly what lay beneath the surface. Rebecca Kingston sat across from Daniel that evening, reviewing the survey report with narrowed eyes. "If this report is accurate," she said finally, "then whoever orchestrated that seizure didn't take a worthless piece of land from you. They stole tens of millions of dollars, and they did it through deliberate fraud." Peter Alden explained further that the survey he had unearthed had been filed by a small geological firm decades earlier, commissioned as part of a broader regional study that had since been forgotten entirely, its findings never cross-referenced with any modern mineral rights database. "That kind of oversight happens more often than people think," he told them, tapping the faded pages spread across the table. "Old surveys get buried in archives, technology changes, and eventually someone with the right equipment and the right motivation stumbles onto something everyone else missed. In this case," he added, "the deposits were significant enough that any competent mineral rights firm would have paid handsomely simply for exclusive access to negotiate." Rebecca spent the following days quietly researching the energy conglomerate Alden had mentioned, a company that had spent the better part of 2 years acquiring mineral rights across the county under a series of smaller subsidiary names designed to avoid drawing public attention to its broader strategy. She found filings suggesting the company had already approached several landowners near Ashwood Ridge, always through intermediaries, always offering to purchase mineral rights outright rather than negotiate a partnership. The pattern told her everything she needed to know about how badly they wanted access to that specific stretch of ground, and how much money was at stake in keeping the true value hidden for as long as possible. Armed with that revelation, Daniel filed a lawsuit naming the Ashwood Ridge Homeowners Association, Linda Crawford individually, and Meridian Point Holdings as defendants, alleging wrongful seizure of property, fraudulent notice procedures, and breach of fiduciary duty. News of the lawsuit spread quickly through the community, and Linda Crawford handled the attention with practiced composure, appearing before a local reporter to dismiss the entire matter as the bitter overreaction of a man who simply couldn't accept losing a legal dispute. "He's grasping at anything he can find because he's embarrassed," she told the camera, her voice smooth and confident. There was no fraud here, only a homeowner who ignored his obligations for years. Inside the courtroom, Gary Mercer presented the association's defense with the same polish Linda had shown outside it, laying out the governing documents of the homeowners association, the recorded minutes from the private auction, and the paperwork transferring ownership to Meridian Point Holdings. On paper, everything appeared procedurally sound, each document stamped and dated in a sequence that suggested careful compliance with the law. He addressed the judge with an easy confidence, insisting that the association had acted entirely within its rights under its own governing covenants, and that Daniel Whitfield's failure to respond to repeated notices was the sole cause of the property's forfeiture. "Every citation, every fine, every notice," Mercer said, gesturing toward a thick binder of exhibits, "was properly documented and properly issued. This is not a case of fraud. This is a case of a homeowner who ignored his responsibilities for years and is now searching for someone else to blame." Rebecca Kingston rose only briefly during that first session, her voice calm but unmistakably certain. "We intend to demonstrate," she told the judge, "that this entire transaction was the product of deliberate, calculated fraud, and that every document presented by the defense conceals far more than it reveals." She did not raise her voice, did not gesture dramatically the way Mercer had, and something about her restraint seemed to unsettle him more than any outburst could have. Judge Voss studied both attorneys for a long moment before instructing the court to proceed to witness testimony, her expression giving away nothing of what she already suspected. The turning point came during the third week of testimony, when a woman named Patricia Nash, a former administrative employee of the Ashwood Ridge Homeowners Association, took the stand as a witness for the plaintiff. Patricia had worked directly under Linda Crawford for nearly 4 years before resigning under circumstances she described, under oath, as impossible to continue tolerating. She testified that Linda had personally instructed her, on more than one occasion, to alter dates on official correspondence and to withhold certain notices from the mailing queue entirely, particularly anything related to the Whitfield property. She recalled being told, in Linda's own words, to make sure certain letters never actually left the building. When Rebecca Kingston asked her directly whether she believed those instructions were intended to prevent Daniel Whitfield from receiving legal notice, Patricia answered without hesitation, "Yes, that was exactly the point." Gary Mercer, visibly rattled, attempted to challenge Patricia's credibility on cross-examination, suggesting that her testimony was motivated by resentment over her resignation rather than any genuine wrongdoing she had witnessed. Patricia met his questions without flinching. "I didn't resign because I was unhappy with my salary," she said. "I resigned because I was asked to do something I knew was wrong, and I didn't want my name attached to it when it eventually came out." Mercer had no effective response, and Judge Voss allowed the testimony to stand without further interruption. A postal employee named Tom Ridley followed her to the stand, confirming under oath that no certified mail matching the association's claimed notice had ever been processed through his station during the relevant time period, despite official records showing a tracking number that, upon closer examination, corresponded to an entirely different piece of mail sent to an unrelated address. Ridley walked the court through his station's logging procedures in careful detail, explaining that certified mail left a documented paper trail nearly impossible to fabricate convincingly, and that the tracking number listed on the association's notice simply did not match anything his office had processed for Daniel Whitfield during that period. Then came Karen Doyle, an accountant who had briefly handled bookkeeping for the Homeowners Association, before being let go over what she described as disagreements about certain irregular transactions. Karen produced printed copies of internal emails she had saved before her departure, emails that Gary Mercer's objections could not keep out of evidence once their authenticity had been verified. She testified that she had noticed unusual transfers routed through an account she did not recognize, transfers that seemed disconnected from any normal association expense, and that when she raised the issue with Linda directly, she had been told to stop asking questions about matters above her position. In one email, dated months before the auction, Linda Crawford had written a single line that would echo through the rest of the trial. "Make sure he doesn't find out until it's already done." The courtroom, already tense, erupted into a low murmur that the judge silenced with a single sharp strike of her gavel. Rebecca Kingston asked Karen directly what she believed that line referred to. Karen glanced briefly at Linda before answering. "I believe it referred to Daniel Whitfield and to the sale of his land," she said. "There was no other pending matter at the time that would have required that kind of secrecy." The most devastating testimony arrived when Rebecca Kingston called Dr. Michael Ostrander, an independent mineral valuation expert, to present his findings before the court. Ostrander walked the jury and the judge through detailed geological maps, satellite imaging, and the results of soil composition tests conducted on the disputed parcel. He explained, in language precise enough to satisfy legal scrutiny yet clear enough for laypeople to understand, that the mineral deposits beneath the land represented one of the richest untapped lithium reserves discovered in the region in decades. He referenced a pending mineral rights agreement that had already been quietly negotiated by a major energy company, contingent on clear title to the property. Based on current market valuations, comparable mineral rights transactions, and the volume of extractable material confirmed through soil analysis, Ostrander stated plainly that the true value of the parcel exceeded $31 million. The precise figure, he told the court, was $31,400,000. He explained that the figure accounted for confirmed reserves alone, based on conservative extraction estimates, and that further exploratory drilling could reasonably be expected to reveal additional deposits beyond what current testing had already confirmed. Silence swallowed the courtroom whole. Linda Crawford, who had maintained her composed expression through every prior session, visibly paled as the number settled over the room. Gary Mercer rose to object, arguing that the valuation was speculative and based on an agreement that had not yet been finalized, but Judge Eleanor Voss, a woman known throughout the county for her exacting standards and her low tolerance for procedural games, overruled the objection with a tone that left no room for negotiation. The court will consider all relevant evidence regarding valuation, she said, and asked Ostrander to continue. With the true stakes of the case now exposed, Rebecca Kingston pivoted to financial forensics, calling a court-appointed investigator who had spent weeks tracing the ownership structure behind Meridian Point Holdings. The investigator explained, methodically and without embellishment, how the company had been formed only months before the auction, funded through a chain of transfers that ran through a shell corporation, then through an account controlled by a relative of Linda Crawford, and finally into an investment fund where Linda herself held a documented, controlling interest. The paper trail, though deliberately convoluted, was ultimately traceable, each transaction leaving a digital fingerprint that Linda's carefully constructed anonymity could not fully erase. During a brief recess before the financial testimony began, Linda pulled Gary Mercer aside in the hallway outside the courtroom, her voice dropping to a sharp whisper that a nearby reporter later described to colleagues, though it never made it into any official transcript. "Fix this," she reportedly told him. "You said this wouldn't go this far." Mercer, visibly exhausted after weeks of failed objections, only shook his head and told her that the evidence was no longer something a clever argument could talk around. When court resumed, Linda's composure had thinned considerably, her hands gripping the edge of the defense table as the investigator returned to the stand. Judge Voss listened to the financial testimony with an expression that grew progressively colder as each new detail emerged. Gary Mercer attempted a final objection, arguing that the investigator's conclusions relied too heavily on circumstantial connections between accounts, but the judge overruled him with a tone sharpened by 3 weeks of mounting evidence. "Circumstantial evidence, arranged consistently enough and corroborated by direct testimony," she said, "becomes something considerably more persuasive than mere coincidence, counselor. Your objection is noted and denied." When the investigator finished, she turned her attention directly to Linda Crawford, seated beside her attorney with her hands folded rigidly in her lap. "The evidence presented in this courtroom," the judge said, "describes a pattern of behavior that goes far beyond a homeowners association enforcing its bylaws. It describes fraud, a deliberate breach of fiduciary duty, a conflict of interest concealed through shell entities, and a calculated effort to prevent a legitimate property owner from ever learning that his land was at risk." Linda Crawford, seated in a chair that suddenly seemed too small for the weight of what surrounded her, broke the composed mask she had worn for months. For the first time since the dispute began, in front of the neighbors who once defended her and the reporters who once quoted her confident denials, she wept openly, her carefully built certainty collapsing into something raw and undisguised. When the trial reached its final session, the courtroom filled beyond capacity, residents of Ashwood Ridge crowding the gallery alongside reporters who had followed the case since the first mention of hidden mineral wealth. Judge Voss addressed the room with the measured authority of someone who understood the weight her words carried, not only for the two parties directly involved, but for the community watching the outcome unfold. She began by voiding the original auction in its entirety, declaring the transfer of ownership to Meridian Point Holdings null and legally invalid due to fraudulent notice procedures and deliberate concealment. Full ownership of the parcel, she ruled, was restored immediately to Daniel Whitfield, along with clear and unambiguous title reflecting its true legal history. She then turned to the Homeowners Association itself, ordering it to compensate Daniel for the extensive financial and legal damages caused by its officers' misconduct, a sum calculated to cover not only his legal expenses, but the extended period during which he had been wrongfully denied access to and control over his own land. Linda Crawford, the judge continued, would bear personal responsibility for the fraud she orchestrated, stripped of any protection the association's insurance or legal structure might otherwise have offered her, precisely because her actions had been deliberate, calculated, and conducted in direct violation of her fiduciary obligations to the very community she claimed to serve. Judge Voss paused before her final ruling, looking directly at Linda for the first time since testimony had concluded. "What troubles this court most," she said, "is not merely that fraud occurred, but that it was carried out by someone entrusted with protecting the very community she chose to deceive. Positions of authority exist to serve the people who grant them, not to be quietly weaponized against a single resident who refused to comply with an unlawful demand. That breach of trust, in this court's judgment, deserves the fullest consequence the law allows." Finally, Judge Voss ordered the full case file, including every piece of financial and testimonial evidence presented during trial, forwarded to the district attorney's office for criminal investigation into fraud and forgery, along with a formal referral concerning Gary Mercer's conduct in drafting and filing the fraudulent abandonment notice. The gallery, which had sat in tense silence through most of the ruling, broke into scattered applause as the final words settled over the room, a reaction the judge allowed to continue for several seconds before restoring order. Residents who had once dismissed Daniel's land as worthless dirt now stared at him with an entirely different expression, something between disbelief and quiet respect. Linda Crawford did not wait for the applause to fade. Flanked by courtroom security and her visibly shaken attorney, she was escorted from the room, her face fixed in a blank stare that suggested the full weight of what had just happened had not yet finished settling into her understanding. The criminal case that followed moved with a speed that surprised even Rebecca Kingston. Prosecutors, working from the extensive evidentiary record already assembled during the civil trial, charged Linda Crawford with fraud, forgery, and breach of fiduciary duty, along with a separate charge tied to the falsified certified mail records. Walter Griggs and Diane Foss, the two board members who had participated in the closed-door meetings, cooperated with investigators in exchange for reduced charges, each of them testifying that Linda had assured them repeatedly that the abandonment procedure was legally sound, and that any risk would fall entirely on her shoulders rather than theirs. Gary Mercer faced disciplinary proceedings before the State Bar Association, ultimately surrendering his license rather than face a formal hearing into his role in drafting the fraudulent notice. Linda's trial on the criminal charges took place 4 months later, in a courtroom considerably quieter than the civil proceeding had been. Without the spectacle of a packed gallery, without reporters lining the hallway, the case unfolded methodically, prosecutors walking the jury through the same evidence Rebecca Kingston had presented months earlier. Linda's new attorney attempted to argue that she had genuinely believed the abandonment procedure was lawful, that she had simply misunderstood the requirements of proper notice. The argument collapsed quickly once prosecutors introduced the email in which she had written her own instructions to keep Daniel from finding out until it was already done, a line that left little room for any claim of innocent misunderstanding. The jury deliberated for less than a day before returning a guilty verdict on every count. At sentencing, Linda stood before a different judge, her voice trembling as she attempted to explain herself. "I never meant for it to go this far," she said. "I convinced myself it was justified because I believed I was protecting the community." The judge listened without visible sympathy, then handed down a sentence that included restitution, a lengthy period of supervised probation, and a formal prohibition against ever again serving on the board of any homeowners association or similar governing body within the state. Linda Crawford, once the most powerful figure in Ashwood Ridge, left the courthouse that day with her reputation, her authority, and her freedom all diminished beyond anything she could have imagined. The morning she first signed the papers that stripped Daniel of his land. News of the verdict traveled through Ashwood Ridge faster than any newsletter or community meeting ever could. Neighbors who had once whispered about Daniel's stubbornness now found themselves whispering about something else entirely, about how close they had come to standing on the wrong side of a truth none of them had bothered to investigate. Frank Delgado, the neighbor who had once shrugged off the entire dispute as a fight over dirt and rocks, knocked on Daniel's door a week after the ruling, holding his hat in his hands with an expression of genuine discomfort. "I should have asked more questions back then," Frank admitted. "I just didn't think it mattered enough to get involved." Daniel accepted the apology without bitterness, though he noticed, not without some quiet satisfaction, how quickly people's convictions could shift once the facts became impossible to ignore. In the weeks following the ruling, the energy conglomerate that had been quietly maneuvering to secure mineral rights throughout the region formally approached Daniel Whitfield with an extraction agreement, offering terms that confirmed everything Dr. Ostrander had presented in court. The land, once dismissed as a worthless collection of rocks and weeds, was now formally recognized as one of the most valuable, undeveloped parcels in the entire county, its market value settling precisely where the Geological Survey had placed it, $31,400,000. Daniel did not sell immediately. Instead, working alongside Rebecca Kingston and a small team of advisors he trusted, he established a conservation and development trust designed to manage the land on his own terms, entering into a carefully structured extraction partnership that preserved his majority control while still allowing the mineral resources to be responsibly developed. He wanted, he told Rebecca during one of their final meetings, to make certain that whatever wealth emerged from that land would never again be something someone else could quietly steal through paperwork and closed-door meetings. The negotiations took the better part of 3 months, with representatives from the energy company sitting across the table from Rebecca and a mineral rights specialist Daniel had brought on to protect his interests. He insisted on terms that gave him lasting oversight of how the extraction proceeded, environmental safeguards that went beyond what regulations strictly required, and a structure that ensured the wealth generated from the land would remain firmly under his control, rather than being diluted through outside investors eager to claim a piece of what he had fought so hard to reclaim. When the final agreement was signed, Rebecca told him it was one of the most favorable arrangements she had ever negotiated on behalf of a client, and Daniel simply nodded, aware that the true victory had already happened months earlier, inside a courtroom, when a judge had finally said the truth out loud. The Homeowners Association, shaken by the scandal and the criminal charges that followed against Linda Crawford, underwent a complete leadership change. A new election was held within the community, drawing a level of resident participation that Ashwood Ridge had never seen before, with candidates lining up who had never previously shown interest in serving on the board, many of them motivated entirely by a desire to ensure nothing like the Whitfield case could ever happen again. Frank Delgado, to the surprise of several longtime residents, ran for a board seat himself and won, telling his neighbors during the campaign that he intended to spend his term making certain the association listened to residents instead of quietly working around them. A reformed board was installed under bylaws rewritten specifically to prevent anything resembling what had happened to Daniel from happening again. The new governing documents mandated full financial transparency for every association transaction, prohibited board members from holding any financial interest in properties under association jurisdiction, expanded resident oversight of enforcement actions, and required that any seizure or forced sale of property proceed only through a strict, independently verified legal process involving certified notice, confirmed through multiple channels. The reforms passed by an overwhelming vote at a community meeting that drew more attendance than any single event in the neighborhood's history, residents lining up outside the clubhouse doors long before the meeting officially began. Daniel attended that meeting himself, standing quietly near the back of the room rather than at the podium, though several residents turned to look at him as the vote was called, an unspoken acknowledgement of how directly his ordeal had shaped everything being decided that evening. He did not speak. He did not need to. The new bylaws, drafted almost entirely in response to what had been done to him, spoke clearly enough on his behalf. On a quiet afternoon several months after the trial concluded, Daniel Whitfield stood alone at the edge of the parcel that had once been dismissed as worthless, watching a line of survey vehicles roll slowly across the rocky ground where a sign once read private property under a name that wasn't his. The wind moved through the weeds the same way it always had, indifferent to everything that had happened, to the fines and the fraud and the courtroom that had finally set things right. He remembered standing in this exact spot the day he first found that sign hammered into the soil, the cold disbelief that had settled over him as he ran his hand along its edge, certain that some clerical mistake would explain everything away within a day or two. It had taken far longer than a day or two, and the explanation had turned out to be nothing so simple as a mistake. He thought about Frank Delgado, who now sat on the very board that had once dismissed his concerns, and about Patricia Nash, who had risked her own reputation to tell the truth under oath when silence would have been so much easier. He thought about the version of himself who had once considered simply paying the fines and walking away, rather than fighting a battle that seemed, in its earliest days, entirely unwinnable. He was grateful, standing there in the quiet, that some stubborn instinct in him had refused to let the matter rest. Daniel thought, standing there in the quiet, about how easily power could convince itself it was entitled to take what belonged to someone else, and how thoroughly that same power could collapse once the truth was finally allowed to surface. Somewhere behind him, one of the survey technicians called out a measurement to a colleague, their voices carrying easily across the open ground that had once been fenced off under a name that meant nothing to him. He watched them work for a long moment, unhurried, at peace in a way he hadn't felt since long before Linda Crawford had first set her sights on this land. Some people believe they can steal what belongs to another, simply because they hold a position of authority, he thought, watching the vehicles come to a stop near the boundary line he had once walked in disbelief. But the greatest value of that land was never the $31,400,000 buried beneath its surface. It was the truth itself, finally brought into the light, after everyone had been so certain it would stay buried forever.